Right. The petitioner presented the petition before the court on the 28th of January for dissolution of the marriage contract with the respondent on the 24th of June 2021 at the Federal Marriage Registry. I did not show the government. I don't know whether is that the website of the marriage registry? It's not just for you. What does it say? Particulars of the parties. The petitioner's living address is 31 Adjusted Street, Johnson, Port, Maryland, Lagos. Okay. Whilst the respondent's living address is 11 Adjusted Street, National GST, Babada, Lagos State. Petitioner's given date of birth, 15th of February 1988, and the respondent 30th of August 1979, Nigeria. The respondent's name is study. The petitioner is within the meaning of the Act of the South in Nigeria. There is no child named and no property claimed by the parties. The petitioner pleaded facts upon which dissolution sought in paragraph 8 of the petition, which has been reproduced in the body of the judgment. And the petitioner seeks a decree of dissolution of the marriage on the ground that the marriage has broken down and other orders are set forth in 1858. The petitioner gave evidence that he's a banker and works at Fidelity Bank, besides that the address are stated above. The petitioner, the parties got married on the 24th of June 2021, as stated, and the marriage certificate issued was tendered and admitted as Exhibit BW1A. The petitioner testified that following their marriage, the parties lived together for a year and the respondent moved out in April 2023. The petitioner stated that he got to know the respondent had relocated through a mutual friend of the parties and that he has not heard from the respondent since she moved out in 2022. The petitioner also sought to dissolve the marriage. Learned counsel for the petitioner stated that the petitioner was filed on the 28th of January and the respondent does not object 2025 and the respondent does not object to it being granted. Learned counsel relies on 15.2 of the Acts and also the case of allowing and citation provided. It is tried that the petitioner will have presented the petition before this court that a marriage has broken down beyond that 15.1 of the Act must be able to bring himself within one or more of the facts stipulated in 15.2.8, which has been reproduced in the body of the judgment. Also see the case of the clearing where the court held that for the petition to succeed, one of the ingredients the petitioner must prove at least one of the ingredients in 15.2 of the Act. In the petition, the burden is on the petitioner to give credible evidence to the satisfaction of the fourth portion section with 2.1 and 2, which has also been reproduced in the body of the judgment. The petitioner relies on 15.2e. The court will grant the solution under 15.2e only where the parties have lived apart for 2 years and the respondent does not object to a decree granted. So the case of the citation provided. When the court held that the parties have lived apart for a continuous period of at least 2 years in the presentation of the petition, and the lower court noting that there is no evidence that living apart was for a continuous period of at least 2 years considering the presentation of the petition. We must add that the basic material was between the parties forced them to live apart, as it seems to me that 15.2e does not permit the court to go on a fault-finding expedition. Omotuni and Omotuni relied on the Belwuchi and Belwuchi and Orugo and Orugo. Where 15.2e is proved, the court may dissolve the marriage without fault-finding. The petitioner gave evidence that the respondent left in 2022 and the petition was filed on the 28th of January 2025. This is more than 2 years of the inner fact before the petition was filed. In the totality of the evidence before the court, I'm satisfied that the petitioner has established the inequitable breakdown of the marriage pursuant to 15.2e. From the foregoing, the pre-night has granted, dissolving the marriage solemnized between Yinka and Peter and Sigma people who are Peter on the 24th of June 2021 in the federal registry, having not shown the purpose. If the pre-nights are charged from after 2 to 3 months from today, if there is no contrary with that is the thing. Any representation? Judgment in the case of Olaoye Adewale and Olaoye Ifanike. The petitioner presented the petition before this court on the 28th of November 2024 for dissolution of the marriage contracted with the respondent at the Ikoyi marriage registry Lagos State on the ground that the marriage has broken down. The particulars of the party are reproduced in the body of the judgment, and the facts upon which the petition is sought, as reproduced in paragraph 7 to 8, are also in the body of the judgment. The petitioner seeks a decree of dissolution on the ground that since the marriage, the respondent has behaved in such a way that the petitioner could not reasonably be expected to repay the respondent in general damages of 500,000 naira for emotional torture, injuries, and trauma suffered by the respondent and the respondent. Petitioner gave evidence that he resides as 6 Alabele Ifo Ogun State, and the both parties got married on 27th of February 2015 and stated the marriage certificate was admitted as P1A. Petitioner stated that the respondent left with the original marriage certificate, so CTC center. The petitioner testified that the parties to have been on the 7th of April 2022. He stated that on the state the respondent was discovered committing adultery, and others stated that the respondent has a tendency for drinking excessively. The petitioner stated that the multiplication ensued on the day of the respondent's infidelity. On the day the respondent's infidelity was discovered, resulting in the respondent vacating the matrimonial union under the parties had been separated eventually. The petitioner stated that there is no child of the marriage, but now also for the case of the marriage. Then counsel for the petitioner stated, pursuant to paragraph 70, that the petitioner intends to rely on the fact of desertion 15.2d. It is tried that the petitioner who presents a petition before this court that the marriage has broken down under 15.1 must be able to bring himself within one or more of the facts stipulated in 15.288, as stated in the and reproduced in the body of the judgment, and the court must be satisfied that one of the ingredients of the 15.2 has been put to the reasonable satisfaction of the court as held in EK and EK, and the body to give such credible evidence lies on the petition, as stated in the case of Judge Rock and Judge Rock, which has also been reproduced in the body of the judgment. The petitioner relies on 15.2d on the issue of desertion, and that evidence that the respondent is after the matrimonial union on the 7th of April 2022 and the 28th of November 2024. This is over a year that the respondent has deserted the petitioner. In the case of Mosu and Mosu citation provided, the court held that desertion is a matter of fact and law for the court trying dissolution of marriage to decide. The Court of Appeal in the case of American and American citation provided held that by virtue of 15.2d, of the Act, a court is bound to rule that the marriage has broken down irretrievably if it is established that the respondent has deserted the petitioner for a continuous period of at least 1 year immediately preceding the presentation of the petition. The court went on to say, what is desertion? Desertion is the withdrawal of support and cessation from cohabitation without the consent of the spouse and with the avowed intention of abandoning allegiance, fidelity, or responsibility and remaining separated in perpetuity. Put differently, desertion means abandonment or voluntary withdrawal from marital obligations by a married person without any just cause. Thus, to establish the allegation of desertion, the petitioner must establish 1, physical separation; 2, about the manifest intention to remain separated in perpetuity; 3, absence from the other spouse; and 4, absence of a good just cause or justification. I find 15(2)(d) proved by the petitioner against the respondent, and on the totality of that evidence, I'm satisfied that the petitioner has established the irretrievable breakdown of the marriage pursuant to 15(2)(d). That the green light is granted, dissolving the marriage solemnized between the parties on the 27th of April 2014 and the marriage registry. That the green light shall become absolute 3 months from today if there is no contrary or that this sort. One minute, please. This is what's this case that you called? Come back to the mic. This is proper practice. It's not properly stated. It's not. Yes. OW. Okay. Oh. Counsel sneaked out of court without the excuse of the court. Counsel gave it there. Judgment in the case of Easy and Easy. The petitioner presented a petition before this court on the 24th of February 2025 for dissolution of a marriage contracted with the respondent on the 10th of May 2008 as a going marriage registry, and found that the marriage has broken down in the country. Remember this petition. Giving evidence in this court. This is the person that appeared.
Give me a picture of that.
The petitioner's given address, how do you say it? It's 87 Abiodun Royal Street, no, Estate, Legal State, whilst the respondent's address is 7 Abiodun Street, Calvin Estate, Shelby Option, Legal State. Petitioner has given date of birth, 27 January 1983, and the respondent 8th of October 1980 for Nigeria. The petitioner's maiden name is Impuko. The petitioner is within the meaning of the Act, domiciled in Nigeria. There are 3 children named Victor Chukwuemeka Eze, date of birth 17 September 2008, raised Ikechukwu Eze, date of birth 19th of April 2011, Emmanuel Munachi Eze, date of birth 28th of August, 2014. If you notice any other, please let us speak and correct the title. But in that, there is no property family owned or claimed by the parties. The petition pleaded facts upon which the resolution is 13 paragraph 9 of the petition, which has been included in the body of the judgment. And the petitioner seeks the following orders: a decree of dissolution of a marriage contracted between the parties on the 10th of May 2008 on the ground that the marriage has broken down irretrievably, and order for full custody of the three children of the marriage and other reliefs as the court made it fit to make. The petitioner gave evidence that she resides at the above stated address and that she is into poultry farming. The petitioner stated that the respondent is a husband. The petitioner stated that parties got married on the 10th of May and the married 25th, and tendered the marriage certificate as sent to the PW1A. The petitioner stated that there are three children of the marriage who are currently in her care. She further stated that since the parties got married, the respondent had consistently engaged in irresponsible behavior, despite repeated promises to change. Specifically, the petitioner stated that the respondent's habits included smoking, verbal abuse, and habitual drunkenness, and the respondent's behavior was often publicly embarrassing, occurring even in the presence of the children and in the streets. The petitioner stated that the respondent incurred debts by taking loans from various individuals, which the petitioner was subsequently forced to repay. The petitioner stated that the respondent used her car as collateral to secure a loan of $850,000 from a mortgage company, and stated that to prevent the loss of her vehicle, she was compelled to settle the loan herself. The petitioner stated that the respondent does not pay for the children's fees, and that the respondent left the matrimonial home on the 12th of May 2022. The petitioner stated that on that day, on returning from work, the respondent was not at home, but that she was not worried because it was the respondent's usual behavior to leave the house. The petitioner stated that the following day and subsequent days, when she tried to reach out to the respondent had blocked her, and eventually, when the respondent picked up in February 2024, the respondent told her that it was done and she should move on. The petitioner stated that several efforts made by her and the respondent's parents to resolve the issues proved abortive. The petitioner stated that she has been solely responsible for the school fees, welfare, and general maintenance of the children of the marriage. The school fees receipts were tendered by the petitioner and admitted as Exhibit PW1B 1 to 69. She further stated that she can take care of the children and urged the court to dissolve the marriage. Learned counsel for the petitioner addressed the court, stating that the petitioner has established the fact of unreasonable conduct under 15.2 of the Act. He further stated that the respondent had deserted the petitioner for more than 2 years, immediately preceding the presentation of the petition, and the respondent left on the 12th of May 2022 without the knowledge of the petitioner and has not returned home since then. Learned counsel for the petitioner relied on 15.2D. Counsel for the petitioner stated the facts also support 15.2E of the Act. It is tried that the petitioner presents a petition before the court that the marriage has broken down irretrievably, must be able to bring himself within more of the facts stipulated in 15.2A which has been reproduced in the body of the judgment, and the petitioner has to prove at least one of the ingredients contained in 15.2 as held in the case of EK and EK. Citation provided, and in doing so, the petitioner must give credible evidence to the reasonable satisfaction of the court as stated in Judge Will and Judge Will, and Section 82, 1 and 2 of the Matrimonial Process Act, which has also been reproduced in the body of the judgment. The court will grant dissolution under 15.2E only where the parties have lived apart for 2 years and the respondent does not object to a decree being granted in the case of Ojodu and Ojodu, which I have cited earlier. Where 15.2E is proved, the court may dissolve the marriage without fault finding. The petitioner gave evidence that the respondent left on the 12th of May 2022 and the case was filed on the 24th of February 2025. This is more than 2 years of living apart. On the issue of custody, welfare, education, and advancement of the children, courts are guided by the provisions of Section 71(1) of the Act, which states that in proceedings with respect to the custody, guardianship, welfare, advancement, or education of the children of the married, the court shall have regard to the interests of those children as the paramount consideration and subject thereto. The court may make such orders in respect of those matters as the things proper in the court. Also see the case of Utuchi and the Utuchi citation provided, where the court held that when deciding the issue of custody, the trial judge exercises judicial discretion, and in exercising such discretion, they will take the following into consideration: the ages of the children, education, welfare, general upbringing, arrangement for accommodation, and conduct of the parties. Indeed, the interests of the children at all times shall be of paramount consideration for prescribed. What you see as looks. On the totality of the evidence before the court, I am satisfied that the petitioner has established the irrefutable breakdown of the marriage was contradicting to the of the act from the foregoing to pre-nice granted, dissolving the marriage between the parties. Dissolving the marriage held between the parties on the 10th of May 2008 as the marriage registry. The decree shall become absolute 3 months from today. There is no contrary order of this court. What's on to the proposed agreement for the children's education? The petitioner shall have primary custody of the children of the marriage, whilst the respondent shall have better access to the children. The respondent shall participate in all parental activities in the children's school without hindrance. Where the respondent proposes to visit the children, receive notice of at least 48 hours shall be given to the petitioner, and such access shall not be reasonably denied. Holidays may be shared as agreed by the parties, and at the attainment of 18 years of university education, whichever occurs later. The children shall be at liberty to reside with any of the parents as they so wish. The respondent and the petitioner shall from henceforth be jointly responsible for the children's education and health expenses incidental thereto from now until they shall attain the desired level of education or tertiary school education. The petitioner and the respondent shall be jointly responsible for the general welfare, maintenance, feeding, clothing, medical, and other sundry expenses of the children. That is the judgment of the court. Sorry, that shall attain tertiary level education. Any other thing is totally up to
Assets.
ACO 224. That was Igejukwu said. ACO 5224. That's number 4.
HCO. Why do we have HCT on the judgment? HCO. That is Sergio's, right?
F5.
The HCT, not one of the HCT. Yes.
Clementina and Tomo 5 years. 5 years, they should say. That is fine.
Judgment in the case of 3rd years and anxiety. The petitioner presented the petition before this court on the 24th of April 2025 for dissolution of the marriage contract by the parties on this side of April and the preliminary cases in the ground that the marriage has broken down briefly. Particulars of the parties are stated in the body of the judgment, and the fact upon which dissolution of the sort as stated in paragraph 10 of the petition. The petitioner seeks a decree of dissolution of the marriage on the ground that the marriage has broken down irretrievably, in that since the marriage the respondent has behaved in such a way that the petitioner cannot be reasonably expected to live with the respondent, having disaffected the matrimonial home without just hope. Petitioner seeks full custody of the children of the marriage, whilst the respondent shall be responsible for the welfare and maintenance of the children. In other beliefs, petitioner gave evidence that she's not chronology and resides at 5 Marrakesh Alabuton, Ajah, Lagos State. The parties got married on the 3rd of April 2009 at the Queen Marriage Registry. The marriage certificate was tendered and admitted as PW1A. Parties cohabited at 31 82 Street, Aluyaya, Lagos State from April 2009 to October 2017. She testified that there are 2 children of the marriage named Osodi Alexander, Chukwu Monso, male, on the 10th of August 2012, and Osaide Daniela Buju, female, born on the 2nd of May 2020. The petitioner stated that the children of the marriage traveled to respondent. The petitioner stated that she has been solely responsible for the school fees and the general welfare of the children. She testified that the respondent stopped coming in and refused to pick his call. He testified that the petitioner testified that the respondent came back home one night and the following day slapped the petitioner, picked up a cutlass, smashed bottles, but she ran away for her safety. The petitioner testified that her father brought her back to resolve the issue, but she was chased out by the respondent, stating that it was a taboo for a woman to leave her husband's house. The petitioner testified that cohabitation ceased in October 2017. She also fought to dissolve the marriage and grant full custody of the children to the petitioner was to respond should be ordered to take responsibility for the education of the children. Learned counsel for the petitioner addressed the court, stating that the respondent was duly served with processes and relies on section 15(1) and 15(2) of the Act. It is tried that the petitioner represents a petition before this court on the ground that the marriage has been that individually under 15(1) must be able to bring themselves within one or more of the facts stipulated in 15(2)(a) to H, which has been reproduced in the body of the judgment. And the court has held that for such a petition to succeed, the petitioner must plead and prove one of the facts stated in 15(2)(a) to H, even if divorce is desired by both parties. And the burden to give credible evidence lies on the petitioner. And this must be done to the reasonable satisfaction of the courts in the case of the case citation provided and judgment in section 82(1) and 2, which has been reported in the document. The petitioner relies on 15(2)(f). In the case of Olaniyan and Olaniyan citation provided, the court held that the essential ingredient for dissolution under 15(2)(f) of the Act is simply the act of living apart for a continuous period of at least 3 years. Proof of events or reasons behind cessation of cohabitation for at least a continuous period of 3 years is not a requirement for the grant of a decree for dissolution of marriage under 15(2)(f). The simple act of living apart by the parties for such a continuous period of 12 months suffices. See also Olaniyan and Ajidan citation provided. Petitioner pleaded that cohabitation ceased in October 2017 and the petition was filed on the 24th of April 2025. This is more than 3 years of living apart before the petition was filed. On the issue of custody of the children, courts are guided by section 71(1), which has been petition and cited earlier, known for the case and on the totality of the evidence before the court and satisfy that the petition has established the irretrievable breakdown of the marriage. Pursuant to 15(2)(f) and as follows. A decree is granted dissolving the marriage between the parties. The marriage was held on the 3rd of April 2009 at the Queen Marriage Registry. The decree shall become absolute 3 months from today. There is no hope from the order of the court. Pursuant to the proposed arrangement for the children's education in paragraph 14 of the 51. I hold as follows: the petitioner shall have primary custody of the children of the marriage, while the respondent shall have unfettered access to the children. The respondent shall participate in all parental activities in the children's school without hindrance. Where the respondent proposes to visit the children, reasonable notice of at least 48 hours shall be given to the petitioner. Such access shall not be unreasonably denied. Holidays may be shared as agreed by both parties, and the attainment of 18 years for university education, whichever occurs later. The child shall be at liberty to reside with any of the parents as they so wish. The respondent. The children. The respondent shall from henceforth be solely responsible for the children's education and jointly responsible for the health care, clothing, and general maintenance of at a ratio of 50% each. The petitioner shall be jointly, the parties shall be jointly responsible for the general welfare and maintenance of the children, and the same joint responsibility of 50% shall apply to each parent. That is the judgment of the court. Right.
If they are all wanted before, apparently it's a legal listen. This is precisely what they.
Parties,
They are like
With all respect to the son, but FEAK. Well, my appearance is for the claimant. I apologize for the absence.
judgment in the case of Evangelist Emeka Odisa and Mrs. Grace Sabi Abisi and Grace Sage Iwakwe. The claimant filed a suit at the Ifo Judicial Division against the defendant on the 28th of June 2024 for the following beliefs: possession of a 3-bedroom flat and appurtenances. The subject matter of this suit, lying and situated at 6 Ugidi Close, River Valley Estate, which is Abiodun local government area. The property of the claimant, which the defendant presently occupies, the sum of 1,733,333 naira paying areas of rent and service charge due on the said 3-bedroom flat. Interest at the rate of 1,073,333 at the rate of 25% per annum with effect from 1st October 2021 till judgment, and thereafter at the rate of 30% per annum until the entire sum is liquidated. Mean profits at the rate of 101,666 per month from the 1st of June 2004 until possession is given up by the defendant. An order commanding the bailiffs of this court was opened 3-bedroom flat at 6 Ogidi Close, River Valley Estate, Ojodu Abiodun local government area. Occupied by the defendant and the property found therein, including an unmarked Volvo car abandoned by the defendant at the said premises, be evacuated to the premises of this omnibus cost of 1,500,000 naira. The claimant filed a statement of claim dated 28th of June 2004, and on pages 5 to 10 of the case file, I'm called one witness about the same foundation and that the following experts. Authorization letter dated 21st of November 2023 to Festus AK, SBCW1 notice to quit dated 27 November 2023, SBCW1B 7 days notice of owner's intention to recover possession dated 3rd June 2024. XBCW1C tenancy agreement, CW1G certificate of compliance, CW1E. The payment case. The payment Evangelist Emeka Olise, CW1 of 13 Wakati Adura Street, River Valley Estate, local government area, adopted a statement from both dated 20th of June 2005 on pages 12 to 16 of the case file. It testified that is a property developer and owner of the subject matter in dispute and the defendant is a tenant. The unchallenged and uncontroverted evidence of the payment is that the defendant is a tenant and occupies a 3-bedroom flat as an annual tenant at 6 Ojodu Close, River Valley Estate, Abiodun since the 1st of October 2017. It testified that the defendant has abandoned the premises for about 5 years and left the flat in a derelict condition. The claimant therefore wants to recover the premises for his personal use and family use and the support to evict the defendant. The claimant testified that he instructed his lawyer, Festus AK, to take necessary steps to recover possession of the premises in accordance with the law and to evict the said defendant by letter dated 21st November 2023, admitted as CW1A. Further to this instruction, the claimant issued and served what is titled as a month's notice to quit on the 22nd of November 2023 to expire on the 31st of May 2024. Thereafter, the 7 days notice of owner's intention to recover possession was issued and served as XBCW1C. The payment also tendered as XBCW1G a tenancy agreement dated 1st October 2017, wherein the subject matter by a 3-bedroom flat was laid to the defendant for an annual rental value of 1,100,000. The payment tendered the certificate of compliance in respect of the notices of the notice signed on the defendant. Pursuant to the affidavit of non-service shown by Kumi or Ropi, Bailey for the court on the 12th of July 2024, the court granted the application of the claimant to serve the court processes by substituted means by pasting at the last known address of the defendant. The affidavits of service issued in pursuant to the processes served are on pages 54, 76, 80, and 83 of the case file. The defendant did not file a defense to the suit. Section 14 of the Residential Premises Rental and Recovery of Possession Law of Ogun State 2004 provides for length of notices to determine the tenancy of the party. In this instance, half a year's notice is required for a year tenant, that is section 14. I'm satisfied that the claimant issued a statutory 7 days notice of owner's intention to recover possession on expiration of the 6 months notice. As the statutory notice filed on the 3rd of June, as the statutory notice was filed on the 3rd of June 2024, and the suit was filed on the 28th of June 2025. I'm satisfied that the 6 months notice issued was sufficient for the nature of the tenants. Being an annual tenant, even though I don't know why you wrote 1 month on your notice. See the case of Uzo and Shobernet 2013 citation provided, where the court relying on Nacho and Uzochukwu citation provided, reiterated that the landlord must properly determine the tenancy by service of an appropriate notice to quit and thereafter 7 days notice of owner's intention to recover possession. Since there is no defense, the court is satisfied on minimum proof that the claimant has duly complied with the provisions of the law and is therefore entitled to possession. It is tried that the court will act on the unchallenged and uncontradicted evidence in accordance with the law. See the case of Living Assurance Company and on the issue of arrears of rent and made profits, these are distinct claims. Whilst the arrears of rent refers to unpaid rents during lawful tenancy period, made profits and compensation for unlawful occupation after the tenancy has expired. See the case of Stabilini, Visioni, and Cosmet International Limited, citation provided. The claimant is therefore entitled to main profit from the period his tenancy ended and he failed to yield possession. See the case of Pent Gas Resource Limited and Barreto, citation provided. There is no provision in the Rent Control and Recovery of Residential Premises Law of Ogun State that allows the court to grant an order for interest to be paid on outstanding rent due, in addition to main profits, which are damages for holding over. From the foregoing, I hold that the claimant is entitled to recover the premises described as the 3-bedroom flat at 6 Could Close, River Valley Estate of Abiodun. I therefore make the following orders. The claimant shall recover possession of the 3-bedroom flat and appurtenances, the subject matter of the suit, situated at 6 Could Close, River Valley Estate of Abiodun for local government area, which the defendant presently occupies forthwith. The claimant shall recover areas of rent and service charge due in respect of the aforementioned property in the sum of 1.1073333 as per it, being areas of rent and service charge due in respect of the above subject matter. The defendant shall pay main profits at the rate of 1.1666 per month from the 1st of June 2024 until possession is given up. The prayer for interest is refused. The prayer to first open the door is refused. The claimant shall apply to enforce judgment as provided for after delivery of judgment and in compliance with the appropriate laws in effect for enforcement of judgment. This is the order of the court. So is that all?
Moment.
We still have another one?
Moment.
Hold on.
Okay.